Good morning. Thank you very much for coming along to this Insurance Act presentation by the Griffin Insurance. I'm sure you know the Griffin are your E&O insurers. My name's Nicholas Neil Fraser. I'm one of the risk managers at Griffin, and Rona May is now head of risk management and also the architect of the whole Insurance Act presentation to the membership, which is made up of some 40 members plus a lot of affiliated offices both in the UK and abroad. So actually to get this together, and thank you for asking us, has been, as you can imagine, no mean feat. This presentation is a general one in as much that it's not specifically made, it's not tailor-made necessarily to Howden, it is actually made for the whole membership. So some of the examples and some of the areas we may move into may not directly affect what you do, which I can appreciate may not be wholly relevant to your day-to-day job, but please take away from this what is relevant to you, because I think you'll find that, you know, some of it will be relevant at least to some of you some of the time. We haven't actually given handouts from this, as you'll see, but all this information is on the Griffin website, which you as members all have access to. So all the slides can be looked at and downloaded from there should you want to do so. I'm just going to run through some overall points through the agenda, and Rona then will go through the Act itself, and I'll then come back and go through one or two practical suggestions and words of warning perhaps on how it actually affects you as brokers on your day-to-day job. So it's a fairly sort of straightforward presentation, which I hope you'll find of use. We'll just go through how it affects you, so some of the changes in the law that you know about, some of which you may already know of already, some of the areas of concern and interest for you as brokers, either as individuals within a broking house or as a broking house slightly more generally. Some of the positive outcomes of the Act, longer term particularly, and as I said in perhaps the third bit, what you will actually need to do or perhaps set in motion at least for yourselves and your clients and your markets. So why are we all here? As I said, the changes in insurance law has been some of the most major changes since 1906. And a lot of people in the insurance market reckon these changes should have been done a long, long time ago. But anyway, finally, we've got to the Act of 2015 and in effect from 2016. The date in question is the 12th of August, which some of you may already be aware of. And I would say that where it says policies governed by those laws of the UK, this is not just English and Welsh law, laws of England and Wales. It is also should you have any policies under Scottish or Northern Irish law, but not under the laws of the British Isles, so not Jersey, Guernsey or the Isle of Man. It will have an impact on insurance and reinsurance placements and on brokers and on how you do your business on a day-to-day basis. That 12th of August, I would say, is a certain amount of sort of chit-chat within the market. There's something of a conspiracy theory that some people think it was done at the quietest possible time to sort of guillotine it through when everybody was on holiday. I think that's probably a little alarmist. It's possibly deemed to be the fact that a lot of renewals will be coming up later in the year, so the fact that it's in August is not a great deal to necessarily be worried about. But anyway, from this famous date of the 12th of August, there will be new disclosure rules applying to all new business insurance. As Rona will go into in a minute, consumer insurance policies have already been affected by some of the new stipulations. So this is only in respect of business insurance. But for all insureds, the changes for warranties, onerous provisions, and how fraudulent claims are reviewed, that will change for, as it says, all insurance policies, whether they're consumer or business insureds. There is quite a lot to get through. I would suggest, just out of sheer expediency, if you could perhaps wait to have any questions at the end, because if we enter a sort of long conversations during the presentation, it can sort of slightly break the thread. We've got plenty of time afterwards to go through any points in detail that you would like us to do so. This poster, which is a famous one, obviously you probably recognise it from Kitchener from the First War, is been put up there, I mean, simply because there's an element of complacency within certain broking houses that, oh, well, this is something that just brokers need do, or this is something that, oh, it'll only affect the claims area, or it'll only affect the technical, technical area. As we'll see, that is not going to be the case at all. It is a bit of an element of a rock being dropped into a pond and the ripples spreading out in every different direction. And we will go through the areas where we think the greatest exposure and the greatest amount of activity will come, on an area by area basis. But I think everybody within your organisation or the people that you're responsible for are going to be, will need to be au fait with the Act and how it will affect you. I mean, just briefly, on the placing, producing side, the disclosure requirements most definitely will be needed to be passed on to whoever your clients are, and obviously liaising with your markets, and also dealing with any opting out requirements by the market, more of which are none. On the placing support side or the technical side, there's going to be a lot of changes to language on documentation, concerning duty of disclosure and breaches of warranties and onerous provisions. So people are going to have to know how they work, where the changes are or not, as the case may be. And then obviously on the claim side, once the claims start to come in on policies, incepting after the 12th of August, it's going to be very interesting to see, how valid the claims are, and also how you negotiate with the markets to the best of your clients' interests on their behalf. So, as it says, we can't obviously expect everybody to know everything all the time clearly, but where relevant, as appropriate, as it says, all require a good understanding of the relevant provisions, with the Insurance Act of 2015. Just a quick word about the difference between wholesale and retail. There is a certain, how shall I put it, sort of myth perhaps within the market that if you're dealing with a sort of a business insurance and you're dealing with an insurance professional or reinsurance professional as your client, as an intermediary, there's a feeling that often, they're supposed to know everything that you know, so therefore they don't need to be told, they don't need to be alerted. Well, that's fine as far as it goes, and we find, on the E&O, in the E&O world generally, as long as everything's going well, that is fine. But the most professional insurance professional can become the most unprofessional insurance professional on the turn of a sixpence if things start to go wrong. So I would be very chary of just, as it were, opting out from a broking point of view, but just assuming that because your client is an insurance professional that they don't need to be, if you like, alerted, or you don't need to know that you're happy that they know most of what is going on. As it says, you cannot assume they understand what is required and will pass this on to their client. You have an obligation to advise them. If they in turn don't do it, that is a different matter altogether, but you at least will have acquitted yourself to the best of your ability under the circumstances. This, again, is perhaps slightly involved. Don't worry about it too much, but what I really just want to draw your attention to is the top left-hand box there. I think it says overseas insured or reinsured. Do bear in mind that a lot of insureds or reinsureds that may be based abroad are on policies that are under English law jurisdiction. So I know a lot of you do a lot of international business, so if it's in Taiwan or Costa Rica or Ethiopia, it doesn't actually matter. If it's under English law or the countries in the UK, as far as the Act's concerned, the Act will apply. So don't be misled by that. It has come up a lot. It's often a lot of questions have come up about that, but just do be certain that that is the case. As it says, the Act applies in all cases if the policy being placed is governed by laws of the UK or countries within the UK. So I hope that gives you a bit of a sort of a background to the Act itself. I shall now hand over to Rona, who will go through some of the finer points of that, and I'll leave you in her capable hands and come back later. Thank you.
Thanks, Nicholas. I get to tell you the really exciting stuff about the law, sorry, and then I'll pass back to Nicholas and he'll tell you what you really want to know, which is what, as a matter of practice, you're going to have to do going forward. Before doing that, I'm just going to put in context a bit why part of the Act only applies to business insureds, and that's because, as some of you may know, the law changed from April 2013 as far as consumer insureds are concerned, and a consumer under the Act that came in April 2013 was defined as an individual buying insurance wholly or mainly for purposes unrelated to their trade, business or profession. And from that point, for the first time under English law, there was a distinction drawn between consumer insureds and business insureds. And basically what the Act did is it first of all prohibited basis of contract clauses in consumer insurance contracts. Those basically these nasty clauses you see in proposal forms and wording saying the information in this proposal form forms the basis of this contract, which actually in legal terms means that every single piece of information that's given pre-contractually to the insurer is considered to be a warranty. So any inaccuracy at all, whether it's material or otherwise, is enough for the insurers to walk away from the policy. That's actually what basis of contract clauses mean, and they've been outlawed for consumers since April 2013 because they're felt to be completely draconian. And the other thing this Act did for consumer insured is it changed consumer insured's disclosure obligations. So again, for the first time, there's a distinction drawn between business and consumer insureds in terms of what they had to do to give disclosure to insurers. It completely turned on its head the regime up until then. So instead of the insurer being entitled to sort of sit back and the insured having to voluntarily tell the insurer anything they may want to know about the contract, having to give full material disclosure of anything that may be relevant to the risk, it turned that on its head, and the onus became on the insurer to ask the questions of the consumer insured that they wanted information about. And as long as the consumer insured doesn't misrepresent the position and answers the questions honestly and accurately, then that's sufficient to have met the requisite standards. It's very much for the insurer to ask what they want to know rather than sit back and say, tell me what I might want to know. And for the first time, again, proportionate remedies for breach were brought in. So up until that point, it had been the same for consumer insureds, where if there were non-disclosure of some piece of material information, the insurer was entitled to avoid the whole policy, which again is quite extreme outcome. So since April 2013 for consumer insureds, there have been a range of proportionate remedies instead in the event of non-disclosure. And that's easiest really to explain by looking at this sort of diagram here. In the event of a breach of the duties, so having failed to answer the questions honestly and accurately, etc., and there being some non-disclosure, where the non-disclosure is deliberate or reckless, and that basically means that the consumer insured knew information was untrue or really didn't care whether or not it was untrue, and it was clearly something that was relevant to the insurer, then in those circumstances, the insurer is still entitled to avoid the policy, which is fair enough, and in that situation also the insurer is entitled to retain the premium. But anything less than that, so where the non-disclosure or misrepresentation is careless on the part of the consumer insured, which would often be the case because they don't necessarily understand the rules properly, then in that situation there's a range of remedies, and the idea is to put the parties in the position they would be in had the thing been done properly in the first place. So if in fact, having received the information, the insurer says they wouldn't have actually written the cover on any basis, then they're still entitled to avoid, so that's the other box in red there under careless, they're still entitled to avoid the cover and return the premium to the insured. Again, that's sort of fair enough. But if in fact they would have written the cover, but they would have imposed different terms, or perhaps they'd have charged a different premium, the idea is that that's what should happen going forward. So the different terms should be applied to the cover, or any claim should be proportionately reduced to reflect that it wasn't actually rated properly, that the insurer didn't get the premium they were entitled to. So that's been the position for consumer insurance since April 2013, and the Insurance Act now is sort of catching up on that element of what's happened as far as business insureds are concerned, because business insureds, as far as disclosure is concerned, have remained unchanged. So what the Insurance Act is doing then is it's prohibiting basis of contract clauses for business insureds. So that basically means that they'll be prohibited across the board. And I'll talk a bit later about elements of the Insurance Act which parties can contract out of, business insurers can contract out of parts of it. But the ban on basis of contract clauses cannot be contracted out of, so they're being consigned to history. So those words should be removed from any documentation that says this forms the basis of the contract. If they remain there, they won't have the current meaning. They won't be interpreted in the way they have been to date. They're felt to be completely out of kilter with a 21st century marketplace. And also, the Insurance Act is changing disclosure obligations for business insureds. So a whole raft of the Act just applies to business insureds for that reason, because it's already changed for consumer insureds. So just to put the changes in context, on the left you'll see the current position for business insureds. There's this principle of utmost good faith, and as you'll all know, the business insured must disclose all material facts which he knows or ought to know. That's the current test, and the insurer can basically just sit back and receive that disclosure without having to ask anything specific. Going forward, there's going to be this duty of fair presentation, and there's now two limbs to the test. You'll see on the right, the first limb is that the insured must disclose every material circumstance which he knows or ought to know. But then the second limb is, failing that, the business insured must disclose sufficient information to put a prudent insurer on notice to make further inquiries. Now, from a practical point of view as brokers, it's really the first limb that's important to you. The position remains that clients need to be told that they need to disclose every material circumstance which they know or what they ought to know. The other is a fallback position, really. It's the second bite at the cherry, to the extent that something hasn't been disclosed, but it's quite clear from the information given that there might be more that the insurer would want to know. What the Act refers to as signposts. If it's quite clear there's some signposts in the presentation, then the insurer is under an obligation under this second limb to actually go back and ask those further questions. And if it's quite clear from the presentation that there might be further information out there and the insurer doesn't go back and inquire further, then they can't do anything about that after the event. The standard's been reached. But from a practical point of view, it wouldn't be a good approach, a starting approach, to give clear indication there might be more information, wait and see whether the insurer asks. The safe starting premise clearly needs to be to tell them as much as they ought to be told to write the risk properly. The Act says that a disclosure must be reasonably clear and accessible to a prudent insurer. And in terms of the knowledge, where it's an individual, obviously, then they know what they know or what they ought to know. But where you've got a more complicated, large corporate entity, the knowledge will be deemed to be the senior management of that organisation and those responsible for arranging the insurance. And it's quite clear that those responsible will go beyond people actually employed by the organisation themselves and will, for example, include the insurance broker. And that's a really important practical point, because it may be that if you're involved in an account year on year, you might actually build up a significant body of information about a particular account, a particular client. And it might be that you end up with a superior knowledge to people within that organisation that might have changed. You might have more recent additions to the team of people actually arranging the insurance. And although the law as it is now, this change to the law is going to remove the obligation of disclosure on a broker itself, your knowledge will be deemed to be the knowledge of the insured. Under the law of agency, something the broker knows is part of that team of people within the insured that needs to be embraced within this search for information. So very, very important to have clear records of information going on year, so that to the extent there's something lacking in a presentation which is in your knowledge and hasn't come through, that's something that can be picked up. Again, the Act talks about the disclosure needing to include information that would be reasonably revealed by a reasonable search. So that's all really helpful, isn't it? Who knows what's reasonable? There's going to be, Nicholas will talk about this more in a moment, but it's going to be really important at the outset, before everybody's used to the new regime, to have lots of dialogue, because what you think's reasonable is, it's very subjective. So as much agreement as possible with markets as to what's being done, and a clear record of the extent of searches, who's been embraced within the search, and as I say, just an agreement of the base upon which it's been done until people are clear as to whether what's being done is actually definitely reasonable, because there is, inevitably going to be some uncertainty about that. So in terms of the consequence then of breaching the duty of disclosure, one of the main reasons the Law Commission started this huge long review of insurance law, which has gone on for years, is because at the moment the position has been so draconian in terms of breach of the duty of disclosure, entitling the insurer to avoid the contract, or the reinsurer to avoid the contract and completely walk away from the risk. And it's been felt that at times it's been quite an extreme all or nothing scenario. And there have been cases where there have been non-disclosure, which, clearly the information the insurer would have wanted to know. But on the other hand, they've effectively got away scot-free, really, and walked away from some quite significant risks. So it's been felt that really that wasn't appropriate, again, for a sort of 21st century marketplace. So from 12th of August, again, a series of proportionate remedies are going to be introduced, a bit along the lines that have been in place since April 2013 for consumers. So looking at a similar diagram then, from the 12th of August, breaching the duty of disclosure, well, where the breach is deliberate or reckless, and that'll be for the insurer to prove that, but where it's deliberate or reckless, so the business insured really has either known that they're not giving full disclosure or really hasn't cared whether they have, and it's clearly information that would have been relevant. In that sort of scenario, then the insurer is still entitled to avoid and to walk away from the cover and retain the premium. And again, that's sort of fair enough. But where the non-disclosure has been neither deliberate nor reckless, you have this range of remedies. As with consumers, so the idea is that the parties will be put in the position that they would have been in had everybody done what they were supposed to do at the relevant time and had the transaction actually be completed as it should have been. So again, if the insurer can show that they wouldn't have written the risk on any basis, they're still entitled to avoid, but they have to return the premium. But if in fact they would have imposed different terms, possibly excluded the thing that's brought the disclosure to light, they would have rated it differently. They have these options to impose terms that they would have imposed at the time they'd written the risk had they known the information. Or again, reduce a claim proportionately is the remedy where actually they haven't been able to charge the premium that they would have charged. You can see there, again, record keeping is going to be absolutely key. Any underwriter who wants to establish what they would have done had they had the full information is going to be able to show a clear record of the way in which they've approached risks presented to them to have any chance at all of saying, I wouldn't actually have written this at all and I should be able to walk away from this. So very, very important record keeping from that point of view. In terms of this magic 12th August date, for this part of the Act, so the part that deals with business insureds and the new disclosure obligations, this is going to apply to contracts entered into after 12th of August 2016. It's going to apply to any new contracts from that date, but also to variations to existing contracts. And that's quite important because the rest of the Act just applies going forward. But I think the logic with this is that if there's a variation that would require further disclosure to a contract in place, at that point at which the insured or reinsured will be coming back, proffering more information because there's some significant change or something they want added or whatever. At that point, the disclosure should be given on the new regime in place. So it's basically any new contracts and variations to existing contracts at that date, the new regime will apply from 12th of August. Now, don't be too disheartened when you see this with the 3 case names. I promise I'm not going to go in any detail into these. We've included this slide because there've been quite interesting commentary on some recent cases, and these are 3. There are other examples we could have included, where the position would potentially have been quite significantly different had the new regime been in place. The first case, actually, the judge, in fact, said in that case what his decision would have been had the new regime applied. So it's just quite interesting sort of seeing how, in practice, the new regime will apply. The first case, the Galatea, concerned a super yacht which was completely destroyed by fire, and at the time that it was destroyed, it was being insured for 13 million euros. But it transpired that in fact it was also at the same time being advertised for sale for 8 million euros. And the insurers sort of said actually that was clearly significantly overvalued, and that's information they would have wanted to know, etc. And the long and the short of it is that the insurers were entitled to walk away from the entire claim because it was found that there'd been a clear non-disclosure on the valuation of the yacht. But also in the judgment, which was very long and had lots of detail about apparently how difficult it is in fact to value these super yachts and all the reasons why in fact you might have these widely disparate prices. But in that case, anyway, the judge commented on what the position would have been under the new regime, and he said under the Insurers Act 2015, in his view, the non-disclosure wasn't deliberate or reckless because of all this expert evidence about valuations and how difficult it was. So he said the just result in these circumstances would be to treat the insurance as valid in a reduced amount of 8 million euros. So that's what he's saying would have been his decision had the new regime been in place. So as it was, the insurers were entitled to walk away completely. In fact, they'd have paid the 8 million, not the 13. So you can see potentially a fairer outcome, really, a more equitable result. AXA and AIG, in this particular case, AXA wanted to avoid some reinsurance treaties for non-disclosure of loss statistics. In that case, the court found that there hadn't been a fair presentation. Clearly, these loss statistics were material, but the underwriter also clearly had not been induced in any way to write the business. He was clearly writing this sort of business all the time, and it didn't actually make any difference to his underwriting decisions. So on the current test, he hadn't been sort of induced to write the business based on not knowing about this, these other statistics. So they weren't entitled to be off the hook there. But a lot of the sort of legal commentators have been saying under the new regime, it'd be far better to argue, well, okay, we're not saying we wouldn't have written it at all, but we would have written it on a different basis, and that would be the better argument for a proportionate remedy, rather than the all or nothing, well, let us apply the terms or the rating, whatever, that we actually would have applied had we had this full picture. Again, you can see the significance of having records of the way in which these things have been approached historically to have an opportunity to mount that argument. And then finally, the Brit and F&B trenchless solutions. In that case, F&B had failed to disclose information about tunnelling works, And as a result, these tunnelling works had sort of active operations within them when it hadn't been disclosed. And Brit, as a result, were entitled to avoid an entire contractors' combined liability policy. Again, quite an extreme result. And I think the commentators are there, again, sort of saying under the new regime, the fairer outcome really would be for the different terms to have been applied. It may well be these particular works would have been excluded or whatever, but a proportionate remedy probably would have been the better, more reasonable outcome, because I don't think Brit for 1 minute would have said they wouldn't have touched this entire project at all had they known this piece of information. They just would have wanted to know it. So obviously there's some concern that there's going to be a lot of uncertainty for a period. But the idea in the longer run really is that this should end up, when everybody's comfortable with the new rules, with being hopefully a fairer outcome and making, you know, the London market a bit more sort of a 21st century place to do business. So that's the part of the Act that deals with just business insureds. The rest of the Insurance Act deals with all insureds, so basically consumer and business insureds, and that's, as Nicholas has touched on, the changes to warranties and owners' provisions, which is most of what I'm going to talk about. And also the positions being clarified on how fraudulent claims can be treated. So warranties then. Warranties are the other reason why, one of the main reasons why this whole review of insurance law was undertaken, because again it was felt that there were some quite unfair results coming through the court's decisions really because of this breach of warranty automatically terminating a policy from the moment of breach. Legally, that's not something insurers elect to do. It's an automatic thing that happens, and what would happen sometimes is that a claim would come to light and then it'd be apparent that some totally unrelated thing months ago had been breached, and you'd have somebody suddenly without insurance cover, you know, which would obviously be an unpleasant surprise. So very, very extreme draconian outcome. Under the current regime, the insurer is liable for losses up to the moment of the breach, but significantly they're permanently discharged from liability for any future losses. And technically an insurer needs to actually reinstate cover if they don't mind, because as I say, there's this automatic termination is what's happened legally. And the significant point I've just touched on, connection between the breach and the loss is irrelevant, and we've seen enormous problems from brokers' E&O point of view arising out of that, because you know, inevitably if a client has a significant loss not paid because some unrelated provision apparently has not been complied with, the first thing they're going to do is say, hang on a minute, you know, this isn't fair. And the brokers are often the target in that scenario, being asked, why did you include this? I didn't appreciate it, etc. So that's caused a lot of problems really, because it has been, you know, quite inequitable in terms of some of the outcomes. So from the 12th of August, the position will change. Breach of warranty from the 12th of August will result in the insurance policy or reinsurance policy being suspended from the moment of breach until the remedy. So there'll be effectively this gap in cover until the breach is actually remedied and the warranty complied with. It's important to note the words if capable of remedy, because of course there will be some warranties that aren't capable of remedy. An example, there'll be others, is for example warranted no known or reported losses at a point in time. If that's not right, then it's not right. So that's the sort of thing you might question whether or not that should be on there as a warranty. But if that sort of provision won't be capable of remedy, but to the extent the provision can be remedied, cover will come back on. The insurer is liable for losses up to the moment of breach and for losses after the breach is remedied, but you do have this dangerous sort of gap in cover. And again, that's a significant point for brokers, because in terms of your revised warnings, in terms of breach of warranty and all that stuff, you know, the bottom line actually is that people still need to comply with them because they will potentially have a gap in cover. And the fact that, you know, the outcome may not be so bad if they do breach of warranty is really, you know, again, it's not your starting position. The risk management message must still be you need to comply with the warranty if it's on the policy, and not water that down in any sense by saying if you don't actually, you know, who knows, you might still have cover. So again, you know, still dangerous provisions within the policy, but it's not as extreme. And the last point, very significant, whether or not there's a connection between the breach of warranty and the nature of the loss may now be relevant. The Law Commission struggled with this for a long time, and what basically happened is that very much at the last minute there was an extra provision added to the Insurance Act, or the insurance bill that went through, and that is this terms not relevant to the loss provision. And basically this applies not just to warranties but to other owners' provisions, conditions precedent and other owners' provisions within the policy. And it basically gives the insured an opportunity to argue that despite the fact that they've been in breach of a warranty or condition precedent or whatever it is, their claim still should be paid because their breach hasn't actually, or the loss they've suffered hasn't actually in any way been affected by the breach. So if the insured has to show, and it's very much the insured that needs to evidentially prove this, they have to show that the breach didn't increase the risk of loss which has actually occurred. So the idea is to avoid these situations where you have completely unrelated breaches and losses, and give an insured an opportunity to say, hang on a minute, I still should get something from this. The caveat to that is that the provision breached mustn't define the risk as a whole. If it's something that defines the risk as a whole, the insurer is entitled to rely on it. Now, it's quite hard to explain all of that without some examples. So there's just a couple of slides now, just working through a couple of examples to try and explain how we think this will work. So with a sprinkler warranty, for example, well, that's obviously intended to reduce the risk of fire damage. And if the insured suffers fire damage whilst in breach of a sprinkler warranty, then they've got no cover for that. That was the sort of risk that the insurer was clearly trying to sort of mitigate against. And if they're in breach, insurer doesn't have to do anything at all. There's no having to show evidence it made a difference. The fact that it's that sort of provision that's been breached is enough for them to walk away from the loss. But if, for example, the insured suffered flood damage whilst in breach, that's the sort of situation where you can see an insured will say, well, fair enough, my sprinklers weren't being maintained or whatever it was, but, my place has been flooded. So that's just, how can that be fair that I'm not getting any money? That's clearly not made a difference. And in that scenario, it's open to the insured, and it's for the insured to prove that the loss they've suffered hasn't in any way impacted the breach and the loss aren't connected, that the breach couldn't have increased the risk of the loss or couldn't have affected the loss. So that gives a way back in, although they're in breach and they've got the suspension and cover, a way back in to say, nevertheless, my claim should be paid. And actually, if it is that extreme where it is, a sprinkler system and a flood, then really the insurer is still paying out for the risk that they expected to, and that's potentially a fairer outcome. The slide on here, the last case I'm going to refer to, Milton Furniture and Brit. Again, this is just one of these cases where some of the commentators have talked about how this might pan out differently under the new regime, because in that particular case, one of the particular issues was that there was a condition precedent on a policy that there would be an active burglar alarm functioning at the premises and it would be monitored and all the rest of it. And the company had fallen out with their burglar alarm people, hadn't been paying their invoices, and basically the alarm wasn't working. And under the current regime, the fact that the alarm wasn't working when a fire started in the premises would be sufficient. It was a condition precedent that this burglar alarm was operational, etc. And that would be enough. The insurers didn't need to show any prejudice. That would be enough for them to walk away, which is what happened. But of course, under the new regime, people have been saying, well, would they be able to argue that actually the burglar alarm wasn't working, but in fact the premises have suffered a fire loss? So under this term's not relevant to the loss, surely they'd be able to argue that nevertheless they should get their claim paid. And it's quite interesting, it's a very good illustration of how it would depend in every situation on the facts of the case, because in this particular case it was felt that the outcome probably wouldn't be any different, because an intruder had got into part of the premises and had started the fire, and there were smoke detectors associated with the burglar alarm system. So a number of ways in which actually, although the loss suffered was a fire, the alarm may well have had a significant impact on the outcome. So you can see where in a lot of situations it won't be black and white. They will be arguing in that scenario, an insured is always going to try and mount an argument inevitably that it didn't make any difference, but it won't be clear cut, and there will be a lot of negotiation as to what the fair outcome is. But the idea is it will remove these very patently unfair situations that we have at the moment. Another burglar, sticking the burglar on for a minute, again that's clearly intended to reduce the risk of a theft loss. So if the insurer suffers a theft, again the insured suffers the theft, the insurer is entitled to rely on the provision regardless of whether it's actually affected anything. But again, if the insured suffers flood damage whilst in breach, you can see how they're going to want to argue, well, the fact that my alarm wasn't working, I should still get my flood paid for. It will depend, as I've said, on the circumstances. If an intruder has damaged pipework or something, there'll be an argument. If a tank's fallen through a ceiling and would have triggered sensors, it may well be that the alarm might have made a difference. But on the face of it, if you've got some sort of thing where the burglar alarm wasn't monitored or wasn't working a week ago and now you've been flooded, if it clearly makes no difference to anything, the insured has an opportunity to say, you should, I'm still entitled to have my claim paid. And as I say, it should end up with a more equitable outcome. The last of these examples deals with premium payment warranties. We've had a lot of questions about premium payment warranties and whether they're going to be worthless under the new regime, because of course at the moment if you don't pay by the due date then cover terminates, and that won't be the case anymore. Cover will be suspended. We would say really they still have some teeth, because if the insured breaches the payment warranty, cover will be suspended until the payment's made. So it's quite brave to sort of be managing your cash flow by having no insurance cover the whole time you haven't paid the money through. Again, we've had people raising issues as to whether people might manipulate the system and think they've got a loss coming through and suddenly pay. But it'll be interesting to see how it pans out. There'll be moral hazard thing issues there, I think, in terms of getting cover going forward. You've got to be quite brave again to make sure the money goes through the chain in time. And effectively, as long as the money's outstanding, there is a gap in cover. And as and when the money's paid, that cover's not reinstated, that gap remains in cover. So it's not a time on risk scenario or anything. That's the amount of money the insurer's entitled to. And as long as you don't pay, you're not covered. So, they still will have some value, I'd have thought. Again, insurer will be liable for any loss suffered, will not be liable for loss suffered during the period of suspension, but if the payment's made and the breach remedied, cover will be in place for future losses. But of course, the rules that I've talked about concerning terms not relevant to the loss will not apply, because those are designed to deal with specific risk mitigation issues where a provision is there to try and control or mitigate against a certain sort of loss at a certain place and a certain time, and it really is the fire alarm, burglar alarms, those sorts of things. And something like payment is never going to mitigate against any specific risk. So the terms not relevant to the loss, a premium payment warranty would not fall within the provisions of that clause the way it's worded, which refers to any sort of provision which is designed to reduce the risk of a loss at a particular place at a particular time, etc. So this will be the case of premium payment warranties. There will be a gap in cover if they're outstanding. The last slide on this section, I mentioned that the insurer will be entitled to rely on a provision where it defines the risk as a whole, and examples used by the Law Commission were, for example, where a property must not be used for commercial purposes. If there's a provision to that effect, that would be considered to be something defining the risk as a whole, and if in fact an insured suffered a loss which it felt actually was not related in any way to the fact it had used its premises or its property commercially, that's not an avenue open to them. Section 11 of the Act, the terms not relevant to the loss, makes quite clear that and that's the provision the insurer is entitled to rely on, and there's no point trying to mount an argument, okay, I breached it, but so what, because my loss didn't relate to that. The insurer will be entitled to rely on these provisions, and that's made quite clear. Other examples are, for example, where cover will only apply within specified geographical limits, or a specified class of ship is being insured, or where, for example, the minimum age, qualifications, characteristics, etc. of a person insured are specified. Those sorts of things are considered sort of fundamental to the entire risk, and if they're breached, then the insurer is entitled to rely on that, and the new provisions won't help you with that. So that's the end of that section. I'm just going to say very briefly something about fraudulent claims, where the position hasn't really changed very much, but in fact, you'll see the top two, left and right, are identical. The insurer is not liable to pay fraudulent claims, which is fair enough, you'd say, and may recover any sum paid in respect of what turns out to be a fraudulent claim. And it's the second part, really, that has clarified the position. An insurer can terminate the contract from the point of the fraudulent act and retain the premium for the entire period, but will remain liable for relevant events before the fraudulent act. Because before that there was some uncertainty, and there have been some cases which have sort of muddied the waters a bit in terms of what the position was in terms of coming off risk going forward, and also for any claims that had already been paid under the policy. And this now makes quite clear the position. Sort of genuine claims remain paid, there's no repayment of those. The fraudulent claim obviously doesn't need to be paid, and it's quite clear that the insurer is entitled to retain the premium but walk away from the point at which there's been a clear fraudulent claim. So that's really sort of clarification. This part of the Act that I've said applies to all insureds, business and consumer insureds, so warranties, owners' provisions and the clarification of fraudulent claims. That will apply to all new contracts entered into after 12th of August 2016 and variations to those contracts. It's very much going forward. There's no question that you'll suddenly have policies straddling that date where things are going to be interpreted differently. It's very much from that date and variations to those contracts going forward, unless, for example, a market has chosen to apply the new rules early, because that's something they would have had to negotiate with you, and you'd be aware of that. So it's quite clear that this element is future going forward. And then the last slide before we get back to the exciting stuff with Nicholas. I mentioned briefly contracting out by insurers. The idea, some people find this a really weird concept, but there are other acts that give parties the entitled to contract out of their provisions. So it's not unheard of. And I think the idea, the philosophy is that if you've got parties that are business entities that should be operating on an equal footing, in some ways they can sort of contract on whatever basis they like within reason, as long as the parties understand what they're doing. So following that logic, consumer insurers can't contract out of any part of the Act as far as consumers are insurers are concerned, consumer insureds. And so the Act is the position as far as they're concerned. For business insurers, as I've already mentioned, there's no contracting out of the basis of contract ban. So those clauses now are consigned to history, which I think people think not before time, they're terrible things. But other than that, insurers can seek to contract out of all or part of the other elements of the Act as far as business insurers are concerned, but it's quite carefully controlled within the Act. Anything which changes what's considered to be the default position under the Act and puts the business insurer potentially in a less favourable position, the Act refers to as a disadvantageous term, and any such disadvantageous term to be effective has to meet a set of transparency requirements set in the Act, which basically say that they need to be clear and unambiguous, and they need to be specifically highlighted, drawn to the attention of the insured, and they need to be agreed to in order to take effect. And again, quite a significant point from a broker's point of view, because if they're explained to you as a broker by a market that these are the provisions upon which we're not going to go along with the Act, we're going to do something different. If you have that knowledge, then your client is deemed to have that knowledge under the law of agency. Your knowledge is imputed to them. So again, a very clear responsibility to make sure that that information is passed on and that parties understand what they're signing up to if there is a difference between the default position and the Act. And again, anybody acting as a cover holder on behalf of underwriter, there's a slightly different take on it, but again, the underwriter may well be relying on you in that scenario to actually be flagging up and explaining the provisions they seek to rely on and getting agreement down the chain. So there'd be a slightly different responsibility there. But again, it's all about they need to be clear and transparent, these provisions, if they're going to bind. There's been a huge amount of work that's gone into this Law Commission review over a number of years, and it's had a lot of market support. So I think the hope is that over time, when the whole thing beds down, there won't be huge amounts of contracting out because it would sort of defeat the object really. But as Nicholas will mention, there will be some scenarios in which it is likely to happen. So it's something to be aware of. Okay, so we get back to the exciting bit now.
Thank you, Rona. Well, yes, well, perhaps everything, as they say, is relative from the excitement point of view. These certain areas I'll go through as quickly as I can, just the salient points, some of which have already been touched on before. As I said, the contracting out, which may actually be simply because there's no case law. You may find certain markets are just chary. They just decide to contract out of all or some of the provisions, mainly because they don't know which way the legalistic tide is going to turn. But perhaps, more importantly, just going on as it's put under this green area here, I would suggest, unless you've already done so, that you do talk to as many markets as you possibly can to find out what their stance is. A lot of the company market, AXA, Zurich, a lot of the P&I clubs have published a lot of the terms and conditions of how they're going to respond to the Act already. But I would do on a market-by-market basis, certainly do that if you hadn't already started to do it. And do get down anything from underwriters in writing. Don't just leave it to a chance encounter or a conversation at the box or whatever it happens to be. It is going to be very, very important if people are going to opt out that you know what they're opting out of and how, when, who, what and why. Hence that point there, it says case-by-case basis or on a general basis, because it is conceivable that you may have, it's possibly not likely, but it's certainly possible, you may have an entity that, for example, on, say, marine business they do, but on non-marine business they don't, or on long-term business they do, or long-tail business rather they do, or short-tail business they don't. But however it is, just make sure that you know as far as your clients are concerned, because it could come to something of a marketing exercise. If you have a client, for instance, who has, say, in a very esoteric class of business whereby there are only, say, 4 or 5 markets you normally deal with, and one of the markets decides to contract out of a whole raft of things, the client may turn around and say, well, actually, I want that market replaced. And that may require you to start looking wider, or perhaps even in different territorial areas for new markets on, as I said, the more exotic classes of business. Regarding the fair presentation and, as it says, what do insurers wish to see and the timescale for review, you may find, particularly on the more involved businesses and perhaps on some of the more complicated treaties you get involved with, that the whole renewal timetable might have to be extended. So rather than perhaps starting, you know, I don't know, 4 or 6 weeks before, you might want to bring it along to sort of 6, 8, 12 weeks before, simply because you may have more toing and froing between markets and clients as to what has to be presented and in what format. And as I said, as much homework as you can do, as it says there, and clarification as opposed to insurers or reinsurers want, you know, prior to the inception, you know, the better situation you will be in. But again, I know it will vary tremendously from class to class. So, you know, just do what is relevant in your particular sphere. Just briefly on this here in this MOVE area, this is obviously bringing other employees up to speed. I mean, clearly, where you have, you know, more perhaps in the technical area for people drafting wordings or templates, you know, disclosure, the new disclosure rules and with warranties, and also particularly how it may have a knock-on effect on TOBAs. I mean, TOBAs often get drafted once and then get rather forgotten about, you know, renewal after renewal after renewal. It may well be a good time, you know, to check your TOBAs to see if anything that is coming up in the Act requires a change. And obviously, on a more general point, you just make sure that if you're the head of a division or a department, that everybody, you know, who answers to you, who is doing the work, you know, does know what is going on. It's a sort of simple point, but sometimes something that does get forgotten. This last one, don't be too alarmed. It's a bit slightly sort of bit of a labyrinth, but on the website, you can look at it, as it were, so much at your leisure if you want to. I mean, it covers almost everything that possibly an additional support to help insured, as it says, understand their new, in brackets, duties. I mean, clearly not all of this is going to follow you, so you're not necessarily going to need to follow this, all of the time. But it is important that the insurers and people you deal with are fully aware. I just come back to these disadvantageous terms that Rona just referred to. You know, do make certain you do get any opt-ins out in writing, and do make certain that your own files are kept up. I'm sure they are, whether they're paper files or electronic files. I'm sure your files are kept up in an apple pie order already, but it is going to be extremely important. You can imagine if you start getting through controversial losses or controversial coverage issues, that you know exactly where you stand with your markets. On that, and the importance, as I say, of everything being complied with, you know, as relevant. So just sort of pretty much just coming to some summary slides on the home straight now. I mean, this, as it says, the positive outcomes. I mean, once the dust has settled, and I think the markets and the market generally settles down, and things like the basis of contract clauses, as Rona said, have been consigned to the dustbin, as it were, the market should be a far fairer place, and the losses, we shouldn't have these insurers or reinsurers being able just to walk away from completely unconnected losses because of a breach of warranty or condition precedent. As it says, I think the term is fair and balanced between contracting parties. Again, just remember that it's not just England and Wales, it is also Scotland and Northern Ireland, and wherever the insured or reinsured is based is somewhat irrelevant if the has English, as I say, other countries involved. And it's quite an interesting point, this bottom one. We had noticed that quite a few markets, in fact, are adopting some of or all of the measures prior to the 12th of August. So again, you know, you may start to find that some of these stipulations come in before the famous 12th of August. Again, that's the question of just doing your, you know, homework with your markets. On here, the difference, as it says, business insureds and the fair presentation of risk. Do make certain that you may find that you, as Rona Sink has said, you know more about your insured's business, the insured's business than the insured can do. That's particularly the case if you've had a lot of changes in management within an insured in recent times. We've had 1 or 2 examples where effectively you as the broker have had to spoon feed the client information that they themselves should have had on their records, but unfortunately the client's records have either been, you know, destroyed, superseded, they had computer wipeouts. There have been a number of variations of that. So it is going to be very important that you also have access to your records, perhaps of going back a number of years to the 2012 12, the 2013 renewal information. Can you actually get back to that quickly and easily, particularly on your electronic filing or on your, your internal archiving? I mean, it does bring up one or two things that one might not have thought of, for some years, depending on the business. Again, as I said, do check your TOBAs where relevant. It's something that they frequently do get overlooked. As I said, do make certain if the markets are contracting out, either in whole or in part, and get it down in writing. And do make certain that obviously anything is sent to your client in writing. Again, it's obvious stuff, but it's things that can easily get overlooked. These terms, as I think Rona touched on, the reasonably clear and accessible to prudent insurers. I mean, they're very subjective terms, so I think you're going to have a sort of sliding scale on how you interpret and filter information depending on the knowledge and professionalism of your clients. And again, if there's ever any doubt, just go back to underwriters and check, what they require and when. On the warranties, again, it's very important that anything is highlighted as before. It's just the warranties themselves and the MRCs by and large are not going to change visibly, particularly. I mean, there are going to be certain of the LMA clauses that can be added in. Those can be easily downloaded from their website. I think there are 18 standard ones that have come up. Some of them apply to warranties either in whole or in part of opting out, and some of them apply to terms being opted out on either in whole or in part. They sound rather off-putting to have sort of 18 new clauses. In fact, some of them are very, very short. They're often just a couple of paragraphs, so it's not as daunting as you might assume. Again, don't assume that every business insured is as savvy as you are. There have been many cases of where, as I say, the business insureds have suddenly denied all knowledge of ever knowing things which they most definitely should have known. And again, it'll probably all come down to what your files, how your files are composed and what information you keep on your files, should it ever come into any form of dispute. Obviously, with a claim, the claims considerations are going to be probably one of the areas where there is going to be the biggest amount of fog. I mean, simply because there haven't been any claims yet, obviously under provisions that the Act has brought in. So it's going to be very important that, particularly if you've got a split market with certain markets opting out, when a claim comes in, is it valid, is it not valid? Is there something to do with the fair presentation or the disclosure which mitigates against the claim being paid? To make sure that you're able to negotiate, as it says, on your client's behalf, as best as you possibly can to make sure as many claims are legitimate claims, that is, are paid. Yes, I think this pretty much comes towards the end. Again, it's this point about the claims. Or just again, it says, but exposure remains for a broker whose client does not understand the disclosure obligations or implications of a warranty or onerous provision. So the whole risk management of brokers is going to be enhanced, particularly I would say over the next 12 months with all the first renewals coming up from the 12th of August or new inceptions from the 12th of August. That is the end of the presentation as such. I'm just going to hand back to Rona for one final postscript because this is something that has happened since we first started giving the presentations.
Yeah, please don't be upset. I'm not going to come and do another 30 minutes, I promise. Literally in the last 2 weeks, the Enterprise Bill Now Act has received royal assent. And this is nothing to do with insurance largely. It's to do with lots of things about enterprises. There's going to be an enterprise commissioner, all sorts of things to do with business generally. But it's been used as a vehicle to make a small amendment to the Insurance Act. And what it's basically doing is it's bringing into the Insurance Act provisions. So there's going to be an implied term in all insurance or reinsurance contracts that claims payments due will be made within a reasonable time. This is going to be from for policies incepting from 4th of May 2017 because the thing basically received royal assent on the 4th of May 2016. The whole thing of being able to claim for damages for late payment of insurance claims has been really controversial, and it didn't make it at all into the first round of the Insurance Act, and even the terms not relevant to the loss kind of got brought in late, but this still didn't get in. And it's now been sort of got in through the back door through this Enterprise Act. And some of the concerns I think are part of being met, particularly insurers being concerned about large risks and reinsurance and all of that there's going to be unfair pressure to make claims payments whilst there's genuine investigations of claims going on. And the idea now is that the provisions that are going to be added to the Insurance Act will deal with that by making clear that there'll be lots of factors in determining how reasonable the investigations and the time spent pursuing, looking into a claim are, and they'll look at things like the size and complexity of a claim, the type of insurance or reinsurance, factors outside the insurer or reinsurer's control, for example, third-party handlers taking ages, the conduct of the insurer or reinsurer, etc. But the idea is that where there is a genuine delay in what is clearly a due payment, where all of that has gone on and payment is due but not made, that there should be an ability for an insurer to basically mount a claim for damages. The problem to date has been that the way English law approaches insurance claims is that it sees the money paid out as by way of an insurance claim as damages, and you can't claim for damages on damages. So although you can claim for interest on that claim, you can't actually mount a separate claim for damages. All a bit convoluted. So basically what's going to happen is that, for example, if you've got a commercial property owner who's claiming for damage to their property, they'll have that underlying claim and they'll be waiting for that to be paid, and they'll be entitled to interest on that as long as that's outstanding. But as a separate matter, if, for example, they lose a lot of rent because there's been an undue delay and this building they can't repair because they haven't got the money, and X months or years later they're still waiting for the funds to come through, this will give them the ability to start a separate action for damages for that loss suffered. So it'll have to fit in with all the usual foreseeable losses, etc., under English law. So it just gives the ability for them to make a claim. There'll be no contracting out of this provision for consumer insureds, but as far as business insureds are concerned, insurers can contract out of this implied term to make a payment in a reasonable time, a payment due in a reasonable time. For business insureds, which you think would not be hugely attractive from a marketing point of view, basically saying you're not prepared to agree that you're paying claims which are due in a reasonable time. But there is the possibility of doing that. But it makes clear that where the breach on the part of the insurer is deliberate or reckless, so where clearly their behaviour is deliberate or reckless, they wouldn't be able to rely on the fact that they'd contracted out of this implied term. So it's really a bit like the bad faith sort of thing in the States. If it's clear that their behaviour is deliberate and reckless, they can't rely on the fact that, we contracted out of it and you're not entitled to pursue us for these damages. And the other thing that's going to happen is there's an amendment to the Limitation Act. So basically, in terms of whilst an insured is waiting for their claim payment to come through, they will have the usual rules, the 6 years from the time at which the claim payment has arisen to bring a claim for this other additional damages against the insurer for late payment. But once the funds have actually been paid by the insurer or reinsurer, from that point, there's a 1-year period in which they can still mount this late payment claim, but they don't have an indefinite period. I think the idea was for reinsurers and insurers to have some sort of certainty from a reserving point of view, etc., that once they've actually made the payment, there should be some limit within the time within which somebody can say, and actually I've suffered all this other loss because you were so slow. So there's this extra 1 year, and once the payment's been made, otherwise it's the normal rules apply. So we're going to be issuing a bulletin on it from the Griffin, really just giving a little bit more detail. Obviously it's going to be really relevant at the claims handling stage to again keep records of investigations that are going on and why what's being done is reasonable, etc. And it's really the point at which clearly that's all been resolved and the payment is due that insurers or reinsurers should have to start worrying that they might be pursued if they're then slow making the payment. But again, it's going to obviously have to settle down and see how it works in practice. And there's now a year for people to get their heads around what it's going to mean, because it's not going to apply until policies incepting until after 4th of May. So that's that. And then I just mentioned our website, Nicholas mentioned it as well, just a bit of a plug for our website really. As Griffin members, anybody from a Howden computer has got access to the secure area of our website. So there's the general open area and there's a members area, which has got lots and lots of information on it. And particularly at the moment, lots of topical information about the Insurance Act. We've got various bulletins we've issued, and the slides from this presentation will be up there as well, as Nicholas has said. And for example, the frequently asked questions 1 and 2, they've largely come from these sort of sessions that we've done amongst the membership, and we've been asked lots of the same sorts of things, and it just it might be worth just flicking through and seeing whether it's something you might think of after you've left here. But it says what the position is on some of the things that people have been concerned about. So there are precedent documents on there and all sorts of different things. So it's just something there, if you're sitting at a desk, you can sort of flick into, and it's just available. And the other thing I'd say as well is that we are dealing with a lot of queries from members at the moment on the Insurance Act, and again they need to be obviously channelled centrally through your usual Griffin contacts, but there's lots of people within the Griffin qualified to sort of deal with those. We're looking at lots of sort of wordings and one-off queries and things, and it's really a resource there to be used. I'd very much say, if you are concerned about things, do channel those queries through to us, and probably find we've actually been asked already, or we're looking at for someone else anyway, or whatever. So it's worth bearing that in mind. That's that for now. Then I think we're going to have some questions if anyone's got any.
You said that the responsibilities now include, under what the deemed knowledge is the knowledge of the insurance broker. There are obviously going to be problems there because of the chain of information travelling down. I mean, is there anything that you can point out to us to help us in dealing with another broker in making sure that there isn't misinterpretation or information lost in translation?
I think the way to approach it is that the client is the person that you get your instructions from. So where you're dealing in that wholesale scenario, that's really your concern, is your liaison with them, and it's then their concern what happens the next step down. So what you need to make sure is that you give very clear indication of them as to what's required, and don't assume too much, because again we have a bit of a warped view at the Griffin because we see things when they go wrong, but don't ever assume people know what they're doing, because the minute there's a problem they'll say, oh, I didn't know that. So you need to do all what you need to do in terms of the warnings, extracting the information, telling them what you need, and then it's then a question of they then have the problem of sort of dealing, as it were, if you want to call it a problem of dealing with the direct insured. You can only deal with the information passed to you. So everything Nicholas was saying, for example, then would apply to the extent that they pass information to you, which you in any way change or reformat or put a different slant on. You need to check they're happy with it, because they're your client. And anything they've told you or that's come through the channel previously, you'll be fixed with the knowledge of. But you're their agent, so you won't be fixed, or the insured won't be fixed with knowledge way down the chain. So it's the client is the person you're dealing with in the chain, the next person, and everything we've said needs to apply to them as opposed to the original insured. Does that help, do you think? There
may possibly be examples whereby with your client, if you like, the broker or the intermediary, the insurance professional, on occasions we've seen examples where they're quite happy for there to be like a sort of cut through to the direct, there's a sort of a leapfrogging or sort of copying in of you sort of doing it together. But that tends to be very, very much the exception rather than the rule.
And that does throw up another issue entirely, because you need to be very, very careful then, because in terms of your legal responsibilities, it's the person who instructs you as your client that you owe all the responsibilities to. And if you start dealing beyond that, you're assuming responsibilities. So that's quite...
It's very important that if that particular intermediary, shall we say, says, look, you know far more about it and we're just, the post box, and we're quite happy for you to go directly to wherever that person is, and they may even be in another country or another continent, could be anywhere, that you know exactly what sort of possibly murky waters you're getting into, because it's a bit of an abnegation of responsibilities by your client, who will still be the client even if they do absolutely nothing. But again, it's probably very much going to be on a sliding scale on your level of confidence, knowledge, and perhaps approachability of that particular client. Because I think most will be pretty good most of the time, but I'm sure you've probably all got examples of some which are frankly pretty useless.
But the general and safe rule definitely is treat that person you're dealing with as your client. As long as you do absolutely everything vis-a-vis them, it's slightly their concern if somebody down the chain might know things, etc. Your problem will be limited to what they've told you that you should know going forward. So if the person within the wholesaler changes and you recognise quite clearly things that have come through that aren't as comprehensive as the previous year, you'd know that, but you wouldn't be able to know beyond that what else they might have asked, the original client.
Do you think the Insurance Act creates more exposure for brokers' professional indemnity insurance, or actually reduces the exposure for brokers' professional indemnity insurance?
Well, it's very to ask me in a couple of years. I think in theory it should create less. I think the danger is people becoming a little bit complacent, because I think a lot of the exposures remain in terms of people not understanding the extent of the disclosure, for example, or people not appreciating that if they don't comply with certain provisions in their policy, they may have no cover. And I think now, to the extent there's a problem, then the consequence may not be as bad. But from a broker's point of view, as soon as there's a problem, you absolutely are in the firing line, you know, even if you manage to become extractive without there being a problem. The minute anything goes wrong, you will immediately be sort of drawn in, and I think that will remain, and there will inevitably be a period of bedding down where, you know, and other areas of exposure potentially where, for example, in the claims handling situation, where things which quite clearly in the old days would be clear cut, covered or not covered, whether something's breached or not breached, there's going to be the whole scope now for negotiation, like this term is not relevant to the loss, or if something's been breached, but actually, you know, the insured could show that they still should have their claim paid. And so in that scenario, there's going to be a responsibility, a greater responsibility on brokers, for example, to pursue claims payments that otherwise would have been, you know, quite clearly not payable. So yeah, I think in the longer run, it should be more fair and more equitable, and I think that should be better for brokers, because you won't get this, you know, this is just ridiculous, it must be someone's fault mentality. But I think the real danger is people thinking warranties aren't as dangerous now, because from a broker's point of view, if somebody's got a warranty they don't comply with and you haven't pointed it out, then they've still potentially got a gap in cover. So there's still an enormous exposure there. So that, you know, the risk management message for brokers is still, you've got this huge responsibility at the different stages to flag up all of these things. And really now, if there's a problem, the consequences just aren't quite as bad as they were, but there's still, you know, a consequence.
And also you may need to do some tweaking to your internal systems from a sort of tracking point of view, particularly if you do find out that you get, say, split markets or markets contracting out because of this, because of that, and because of the other. It does then mean, if you've just got one market 100%, it's obviously rather easier to track. But if you've got a more of a subscription market that is split in different ways, and different markets are opting out of different things, you know, just tracking, you know, payments and claims and all sorts of coverage issues does become whereby you just had the market. Now you've almost got, you know, the sort of markets A, B, and C in different sections potentially. So again, I could see possibly E&O exposure by somebody, you know, not paying a claim or not getting the right market to respond in the right way because their systems were set up in the wrong way, potentially. So, you know, how you track things is something else you might like to look at.
And the premium payment warranties, for example, actually, because if somebody's not paid, then there's a gap in cover. And as and when the money gets through, cover comes back on. So again, if the money then is paid, you know, it needs to leave your systems very, very quickly. People need to be onto that, because as long as you've received the money, and then if there's any delay at that point, there's still no cover until it reaches the insurer or reinsurer. So that sort of thing, again, is, you know, there'd be the potential there for someone to say, well, you've had all that money, and, you know, how come I still didn't have cover for that period of a few days or whatever. So there will be some slightly different exposures to look out for.
Unless you can then get your slips or documentation to say that, you know, receipt by broker is deemed to be receipt by underwriter, but of course not all underwriters like putting that on. I mean, it helps the broker tremendously, but as I said, they're not always that receptive. But again, perhaps if you don't ask, you don't get. But maybe worth trying.
There was a bit in there that you were saying you should get the clients to sign off on the overall submission to the marketplace. Just wondering about the practicalities of that, particularly on some of our larger cases. You know, we'll do some sort of broken note that ties various bits of information together, gives a bit of history and things. Do you think we should pass that back to the client to sign off, not bung it anyway?
Again, like everything that's put on there, it's quite difficult to say that this that all sizes fit all possibilities. Where I think it may be, if you don't do it already, is perhaps if the client provides you a lot of, say, what you might call raw data, raw information, that for presentation purposes, you, as brokers, you have to rejig, reformat, rework in some way, shape or form, that before you go to the market, it may not be a bad idea to say, look, this is what you gave us, you know, a fortnight ago, we've turned it into this, and we're about to go into the market, and obviously it's not going to look the same as it did when it left the client's office. And I think it's just if it makes sense to do that, because what you don't want to find out, and it's something that, going back to my previous incarnation as a broker, as a matter of course we tended to do this, because what you didn't want the client to then say is, oh, well, I never realised that you told the market such and such a bit of information in such and such a format. But if you obviously sent it back to them before you go into the market and they'd signed off on it, they could never come back to you at least with that. Again, if it works in your relevant class or subclass, do it. Obviously, if it doesn't work or it has to be rejigged, you know, just use it to the best of your ability. Because as I said, these points that we make, I mean, the non-legal points, obviously, are to be used as relevant within, as I say, the classes of business that you work in. So whatever basically makes the most sense for you.
And I think it's quite a general issue there actually, because so much of this is uncertain and people don't really know exactly what's the right thing to do, or whether you've definitely met the required standard. And I think if ever there's a real case for as much dialogue as possible and agreement, a recording agreement as possible, so that if after the event somebody says, I wish you hadn't done that or included that person, or you should have asked somebody to be included in the search, just getting everybody's agreement as much as you can throughout the process has got to reduce the possibility after the event of people saying, you didn't do it how I thought you were going to do it, or whatever. So, dialogue with markets really and clients as to this is how we're approaching it. Is everybody on side? And as much of that as you can have on your file will eliminate question marks after the event, just because there is this uncertainty until the whole thing beds down and everyone's confident with what's being done.
But I take your point entirely about if you've got, what you would call sort of broking points or things that are sort of confidential within the broking house that you wouldn't necessarily want the client to see. Well, it may make sense that if you have it as an integrated document now, that possibly just that bit is obviously taken out or is added as an appendix, and the way you do it is perhaps you just rework, because clearly you don't want your sort of in-house secrets sort of going back to your client necessarily. That is things that are strictly internal within Howdens.
It's a question about claims control clauses where you've got condition precedent to liability. In the control clauses there's notification requirements, cooperation requirements, and cedents can't go ahead and agree a claim without reinsurers' approval. But I think what you're telling me under the new Act, cedents don't have to cooperate and work with reinsurers in the same way. They can perhaps go ahead and conduct themselves as they would perhaps under claims cooperation clause, but underwriters would now have to show that they have been prejudiced by the cedent's conduct under a claims control clause where they've got condition precedent to liability provisions.
The whole condition precedent thing is really interesting because the Act doesn't actually change how condition precedents work at all, other than this term's not relevant to the loss provision. So although you've got this dramatic change in how warranties work, in terms of condition precedents remain the same in terms of how they will operate. So where you've got a claims control clause, for example, as to how, the loss has already happened by then and how the claim will be dealt with, if that remains in the policy, then that will operate as it currently does. The only way in which conditions precedent, because the warranties and other owners' provisions would embrace condition precedent, the only way in which the Act affects those is to the extent that there's a loss and the condition precedent is of a risk mitigation type, and so the breach of something, a condition precedent to maintain an alarm or to act in a certain way or whatever, and that's breached, and then there's the opportunity for the insured to say, well fine, I've breached that, but the loss I've suffered isn't related. So that's the way in which it can impact on conditions precedent. But other than that, so for example, if you've got a condition precedent that a claim will be notified within 14 days and it's notified on day 15, the position will remain, although that might seem unfair, the position will remain that the insurer is entitled to walk away from that claim because the person's a day late notifying. And it's quite interesting because that slightly goes against the grain of the whole Law Commission trying to make everything more fair and equitable, because to the extent that sort of provision remains in a policy, then there still will potentially be what would be considered quite unfair outcomes, and it would be very important for those things to be flagged up. Because the law it changes warranties, it doesn't actually change condition precedent other than this term's not relevant to the loss, causal connection element. So I don't think it will actually affect what you're talking about. Okay, thanks very much everybody.
Thank you for your time and patience. Sure.